I'm curious as to what your either most difficult or most memorable case that you've adjudicated is.
I'm always asked that, and I never can answer it because, you know, there are a lot of difficult cases, and you remember different. It's like having a very large family. You remember different ones for different reasons. And
do you have one that's like particularly emotional, that kind of affected you emotionally, perhaps?
Well, I can't say that. I mean, one tries not to get overly emotionally affected by, but part of being a judge is being able to, at least intellectually, distance yourself somehow. And if a judge is starting to get emotional about, I have to win this point, or I have to drive this home, or I have to establish that agenda, I think that is something you should watch for and be very careful about. So the whole business of judging is standing back, listening to what each party has to say, and conscientiously trying to make the right decision. So, no, when I think of memorable cases, I mean, you can think of some that that really have important constitutional impact. For example, we had a reference on the secession of Quebec a few 12 years ago, but there was a referendum in Quebec that very nearly ended in a vote for something called sovereignty association, which people aren't too sure what it is. It wasn't outright separation, but something less, but still a political kind of division. So the federal government put a reference to the Supreme Court and asked whether a province could unilaterally secede from the country. Now, that's a huge question. Our Constitution didn't say anything express about it. So we had to get together as 9 judges. It's also a politically laden question, and we try to, as I mentioned in the same-sex reference, avoid getting embroiled in political, because we think that's for Parliament. So it was a delicate task, and I think it's one where the court acquitted itself very, very well. We ultimately said that if a province's people on a clear question by a clear majority decided that they wanted to secede, then the federal government would be obliged to sit down and have negotiations. And we talked about 4 principles: principle of democracy, principle of respect for minorities, principle of equality, and the 4th one doesn't come to me, of federalism. And that these principles would imbue they almost are the groundwork upon which the Constitution is set, if you wish. And therefore, while the Constitution itself doesn't say much about secession, you have to look at those principles in resolving it. So again, we kind of threw it back. We said, yes, it could be possible that at least you'd have to have discussions. We have a tradition in our country where we don't fight about these things. We wouldn't kill each other over it. We'd have negotiated discussions about it, and we would try to work it out peaceably. Well, that seemed to please everybody. That's why it's a highlight of my judicial career. It's the only decision we ever made that pleased everybody.
Correct.